The last session we have seen about the breach of contract. When one person fails to perform his part of obligation under the contract, we call it as a breach of contract. If this breach has caused some damage or some loss to the other person, then the person who has breached the contract, the person who has failed to perform under the contract has to compensate the other person. The losses suffered by the other person should be compensated by the defaulted person. This is a rule. Regarding the compensation, what is the amount of compensation? One thing, he has to make payment of the losses he has suffered. Compensation for the losses, number one. Number two, the other person may claim the incidental losses also. For example, if he has spent some money on travel along with the other business loss, he can also claim that is incidental losses. Third is, at the time of making the contract itself, they might have decided this will be the damages in case of our failure, in case of one person's failure to perform. That is, in case of breach of contract, what will be the damages payable will be decided by the parties at the time of making the contract. This is called liquidated damages. The fourth one is as a penalty. When the bank dishonor a check, even with the balance in the account, then it is called as a punishment, damages are awarded. Regarding the performance, the other person may, when there is a breach, the person may move to the court to make the person to perform. For example, if a person has agreed to sell his house and on the due date he is not agreeing to execute a sale deed, then he can move to the court. The court may order him to do the performance, specific performance. Second, they may decide not to insist upon the contract itself, or the parties may alter the contract and do performance. Regarding the damages, section 73 and 74 of Indian Contract Act deals with the damages. Damages will be for the actual loss, and the remote losses occurred due to remote causes will not be taken into account. Only the losses occurred due to immediate cause will be taken into account. One example, one case is Ramkumar Agarwala versus Lakshminarayan Agarwala. Under this case, a person was dealing with oil. The supplier gave some adulterated oil. Because of that, the government people came and they took the oil and filed a case against the person. He was imprisoned for 2 months. What are the results here? One is the cost of the oil. The government has taken the oil. Second, cost of the case, amount paid to the advocate, the court expenses, all the expenditure, travel expenditure, mental agony, loss of business for 2 months, loss of reputation, all these things because of only one reason, because the other person has supplied adulterated oil. The person claimed for business loss and other losses, but the court held it is only the immediate loss only considered. They gave the compensation only for the oil and the expenses regarding the conduct of the suit. There is another case, Hadley versus Baxendale. In this case, there was a mill, one shaft for the machine broke down. It had to be sent to somewhere. They went to the transport office, told the person it had to go urgently, but somehow that was not sent. As a result, the unit was closed. The factory was closed for 1 month. They filed a suit for recovery of damages for 1 month business loss. But the court held it cannot be claimed unless the other person is intimated about the intention and the loss to be incurred. They made a distinction between the damages. They said the general damages and special damages. General damages is the damage ordinarily a person incurred because of the breach of contract. But the special damages can be claimed when the person has intimated the other person about the damage, about the losses likely to be incurred in case of a breach, and he has to prove that he has incurred the loss. In one case, Simpson versus Northwestern Railway. In Simpson versus Northwestern Railway, the person sent some goods. On the consignment notes, he wrote as must be at Newcastle on Monday certain. Must be at Newcastle on Monday certain. That is definitely it should be there on Monday. It was for some exhibition. He sent some articles, but the railways did not deliver in time. He approached the court for compensation for damages. The court awarded damages because he has indicated indicated about the likely loss he may incur because he has made it to be delivered on Monday set time. The Indian law is same. Section 73 deals with that. Claim will be made only for the initial the actual losses. In case of losses for remote reasons, it has to be intimated. But what they say is both the parties should have something on the mind at the time of making the contract. One case, Madras Railway Company versus Govinda Rao. Under this case, one person sent a sewing machine and dress materials by train to some other place to be there before the festival. But this was not intimated to the railway authorities. It was delayed. When he claimed for the business losses, the court did not allow because it was not intimated to the railway authorities. Next is there is a duty to mitigate the losses. When there is a breach of contract, it is the duty of the other person to reduce the loss as much as possible. For example, a person agreed to buy some goods at 100 rupees, but on that day he did not purchase that from the seller. So what the seller has to do is he has to sell it at the market rate to some other person, maybe 80 rupees or 70 rupees, and claim the difference from the other person. Because of breach, I have incurred a loss of 20 rupees, so you give it to me. Same is the case if a person has not supplied it, the other person has to source it from some other place and the price difference has to be taken from the person. Because of your breach of contract, I have incurred this much of loss. There is a duty to mitigate the loss, make action to reduce the loss. Then there is one more damage called nominal damages. Under these nominal damages, there is no loss to anybody, but just to punish the person who has breached, who has not done his performance, some damages is awarded. In one case, Charter versus Sullivan. In this case, a person booked a car but he has not taken delivery. The other person approached the court. The car is in heavy demand. The seller can sell it to anybody. Within days he can sell it. However, he approached the court to punish the person. A nominal damage of 40 shillings was awarded. Just to say that this person has not done his part of contract. Then another one, punitive damage, that is as a punishment. When the banks dishonor a check, even though their balance is in their account, then it is a punishment. Not for actual, it is something more than that. For example, in one case, Western versus Oleg State Bank, this person was planning to move to some other country for a tour. He approached the bank for money as a loan. The bank, he executed all documents and the bank promised the account will be credited. But the account was not credited. The other person suffered in the other country. Bank, he approached the court, filed suit for compensation. He was given compensation because the bank has failed in their duty. Then liquidated damages. Liquidated damages, section 74. Liquidated damages, the damages which the persons have agreed at the time of making the contract itself. They quantify the damages at the time of contract and they enter in the contract agreement itself that this will be the damages payable in case of our failure to perform. Under English law, if the liquidated damages is by way of penalty, courts will not enforce it. But in Indian law, the rule is different. The courts will award damages subject to the maximum amount specified in the contract. If the contract is specified the liquidated damages as 10,000, even if the person has lost money to the tune of 15,000, courts will award only 10,000. If the court decides the reasonable amount is 5,000, it will award 5,000 even if the agreed liquidated damage is 10,000. The courts will award any amount which is lesser than the liquidated damages. It may be lesser or it may be equal, but not more than that. This is the rule under the Indian law. Next is a compensation to partly rightfully rescinding the contract. In some cases, the party may avoid the contract. For example, one person has agreed to sing in a program for 7 days. He came for 5 days, 6th day he has not come. Then the other person has a right to rescind the contract. In that case, the person who has rescinded the contract has the right to claim damages. In our next session, we will see about the quasi-contract.